Good morning.
Good morning.
Good morning. Can I just sort myself out a little bit?
Yes, by all means. Can you hear me? Hello?
Yeah, you're audible.
All right.
Good morning. Yes.
Good morning. I'm trying to join the hearing rooms, but I'm not able to. Can you hear me? Sorry.
Hello, it's Michael Patrick Joyce. I can hear you.
Good morning. How are you?
I'm well. I wouldn't mind, because it's 5 o'clock in the morning here and I just got into chambers, wouldn't mind having 5
Looks
minutes.
dark.
It looks dark. It is dark. I wouldn't mind having 5 minutes just to gather my thoughts. Could you start by telling me, because I know I'm doing 2 judging back to back, which
Hello, can anyone hear me?
Yes, Mom.
Are we audible to each other? Is everybody else able to hear each other?
Yes.
Yes, we can hear you, woman.
I guess we're just missing someone to start us off.
Morning, everyone. Can you hear me?
Yes, we can.
Yes, we can.
I can.
Hi, everyone. I'm just coming into some of the rooms to check and see if you've got started. I think you're missing some judges. So I will see what I can do about that, okay?
All right, thank you.
Thank you so much.
This meeting is being recorded.
Hi, good morning, everybody. I think I'm, at the request of DIFC, I'm just sort of taking over as a judge till the scheduled judges join. Can you hear me? Can anyone confirm they can hear me?
Yes, we can.
Yes, sorry.
Perfect. So this is Middlesex. Sorry, Middlesex University I versus Middlesex University H.
Yeah.
Perfect. So can I request the appellant start?
Hi, good morning, everyone. Should I start?
Yes, please.
Okay. May it please the court. My name is Zainab Raheel, and I'm the senior appellant of the counsel for Mr. Leith Payne. I will be assisted by my learned junior, Mariam Majid. The respondents in this case are represented by my learned friend Nabiha and Momin. For the benefit of your honor, the facts of the current case will now be represented. The appellant and respondent are both users of the Clevity platform, where users can create an account and trade in cryptocurrency. A minimum of 50,000 US dollars cash margin should be maintained in the user's accounts as a condition of trading in the platform. YAPL, a cryptocurrency, is automatically purchased by the respondent's alpha program at best possible Clevity price. The price at which YAPL is offered on the platform is based on the average pricing for YAPL, as shown in the appellant's beta program. However, if no other users offer to sell YAPL, beta is programmed to automatically offer it at a greatly inflated price. During a routine upgrade, an error was made on June 10, 2022, causing Clevity to wrongfully exclude users who had less than $200,000 in the margin instead of the 50,000 margin that was intended. There was a glitch for 30 minutes. The only two users with margins above 200,000 at the time of the glitch were the respondent and the appellant. As a result, an automatic trade was concluded in which the appellant sold 100 YAPL for a price that was 250 times higher than the going market price, debiting the respondent's account by $250,000. The parties agree that the contested trade was concluded at a price that was 250 times higher than the going market rate. The respondent issued proceedings in the DIFC Court's Digital Economy Court, seeking a declaration that the disputed trade was void for unilateral mistake. Your Honor, I will now address you on the first ground of appeal, namely that DIFC does not have jurisdiction under Article 5A(1)(b) of Judicial Authority Law. My learned junior will be addressing the second ground of appeal, which states that the court stated that it is not necessary to examine the programmer's state of mind when designing the program under Article 37(1)(a) contract law. In common law, courts have general jurisdiction, which means they have the authority to hear any dispute over subjects to the extent that it has been given by the Constitution and legislation of the sovereign it represents. However, they hear conflicts except for those forbidden by state law. Some states, for instance, refuse subject matter jurisdiction for cases that do not involve state citizens and did not occur in the state, and those reserved for federal courts with exclusive jurisdiction. I refer your honor to the Mansfield Co. versus 111 U.S. 379, 1884 case. It was said that the power to declare the law is known as jurisdiction. Without it, no claim may proceed in court. I will now represent the facts of the case.
Sorry, just to interrupt you. So what was the factual background of the case you just cited?
Yes, I will represent the facts of the case now. Okay. In a case filed in Ohio State Court, the claimants in two corporations with offices in Ohio and Michigan sought damages from the defendant railroad company and another entity for alleged violations of a contract for building a railroad. Claiming the partners were not Ohio citizens, the railroad corporation requested that the case be transferred from state court to federal court. The court determined that the Federal Circuit Court lacked jurisdiction over the case because the railroad company was not eligible for removal since the partner's citizenship was not expressly stated in the railroad company's pleadings. Similarly, Your Honor, both the parties, Ms. Rani and Mr. Payne, were not members of the DIFC and did not reside in the DIFC, hence the DIFC jurisdiction could not apply. Your Honor, I have two submissions to support this ground. Firstly, only one of the nodes is on a server based in the DIFC. The platform Clevity works on different nodes based on foreign servers worldwide to make online trading possible. One such node happens to be on a server based under DIFC. Node is a component of cryptocurrency required for most popular currencies. The nodes are based physically in different parts of the world to conduct a transaction online and are based on other servers. It is difficult to determine whether the transaction could have happened on servers not located in the DIFC. Moreover, Your Honor, it is uncertain if the upgrade affected the other servers that regularly participated in transactions and were based in DIFC. The subsequent transaction might have happened on servers located elsewhere that were not part of the DIFC. Therefore, in terms of interpretation, it can be difficult for Clevity clients to ascertain whether or not the server or node they choose through their server performs a transaction. Furthermore, Your Honor, transactions taking place from anywhere in the world from different servers can result in fraud. I would like to bring to your notice the D. Aloya versus Persons Unknown 2022 case, where the claimant claimed that the defendants had fraudulently misappropriated cryptocurrency. The first defendant's brokerage website hosted two digital wallets where the claimant had made multiple cryptocurrency deposits. The website appeared to be connected with a legitimate US regulated business, but it was not. The claimant was domiciled in the jurisdiction of England. The fraud was practiced upon him in this jurisdiction, hence the court granted damages to the claimant. Your Honor, my second submission states that the jurisdiction did not apply. Alternatively, both parties were not present in the DIFC when the transactions occurred. Clevity is a programmed software that utilizes its own algorithms and does not request the user's consent before choosing the appropriate servers for a transaction. The party's physical location was not in the DIFC. Transactions were conducted between the two parties on the DIFC-based server made available and accepted by the Clevity platform. This was done to make it evident that neither party had any influence over whether the server was based in the DIFC or not. In addition, both parties must reside in the jurisdiction for the rules and laws to be applied to the trade that is going to take place. In the case of Skate versus Solo Capital Partners 2022, the court erred when it determined that the Danish tax authorities' request to recover tax refunds that were allegedly prompted by the deceptive promises of firms based in England constituted an attempt to implement a foreign tax law directly or indirectly. As a result of both parties residing outside the DIFC, trading outside the DIFC prevented the jurisdiction from being applied to them. In the appellant's view, I would like you, my honor, to overrule the decision made in the court of the first instance. My honor, I will now be moving to my conclusion. In conclusion, no jurisdiction resulted in DIFC rules not applying to them. My learned junior Mariam will now address the second ground of appeal, namely that the court stated that it is not necessary to examine the programmer's state of mind when designing the program under Article 37(1)(a) contract law. I would like to invite your honor to hold the decision in the Court of Appeal and overrule the decision made in the court of the first instance. With that, your honor, this concludes my submission for the appellant. Thank you.
Thank you, counsel.
Thank you.
I think your co-counsel can carry on.
Your Honor, as you have heard, my name is Ms. Maria Majid, and I shall be addressing the second ground of appeal on behalf of the appellant, Leith Payne, namely that the appellant, being the reasonable trader, did not have knowledge of the circumstance. I have two submissions to make, which can be found in my skeleton argument on page 6 and 7. First, both parties committed to the transit through the functions of the algorithm. Second, the respondent should have been aware of the risk. If it pleases Your Honor, may I proceed with my first submission?
Please proceed.
First, both the parties committed to the transit through the function of the algorithm. In this case, the disputed trade is not an error and is valid under the smart contract. For Your Honor's understanding, I would like to give a brief definition of what smart contracts are. Smart contracts are programs stored on a blockchain that run when predetermined conditions are met. They are used to automate the execution of an agreement so that all participants can be immediately certain of the outcome, without any intermediary involvement or time loss. They can also automate a workflow triggering the next action when conditions are met. If it pleases Your Honor, I would like to refer Your Honor to the case Chu Kim Kyung and DigilandMall.com Pta Limited, reported in the first volume of the 2006 Law Reform Commission at page 37. For Your Honor's benefit, I would like to direct you to page 6, para 10 of the skeleton argument in the appellant bundle. For further judgment on the case, I would like to guide Your Honor by clicking on the case in the index on page number 1. Would Your Honor prefer a brief summary of the following case?
Yes, a brief summary would be helpful. Thank you.
The respondent was a company that sold information technology products across the internet. As part of its business, operated a website owned by Hewlett-Packard and its own website, known as Digiland Mall website. On 8 January 2003, employees of an entity related to the respondent, Digiland International Limited, which from further this point, Your Honor, will be referred as DIL, were undergoing a training session at the respondent's premises. A DIL employee inadvertently loaded contents of the training template onto the Digiland Commerce website, which then automatically and instantaneously initiated the insertion of similar contents onto all three websites. As a result of the mistake, the price of the laser printer was advertised at the wrong price of $66. The actual price was $3,854. All 6 appellants were graduates conversant with the usage of the internet and its practices, and endowed with more than an adequate understanding of business and commercial practices. In the early hours of 13 January 2003, the 6 appellants placed order over the internet for 1,606 of the printers. Confirmation notes were automatically dispatched to the appellants through the email. When the respondent learned of the error, the advertisement was promptly removed from the website, and the appellants and the other 788 buyers of the printers were informed that the price posting was an error and that the respondent would not be meeting the orders. The appellant that brought legal proceedings seeking enforcement of the grants. The appellants it was submitted on behalf of the appellant that the contract was binding and one which the respondent was obliged to honor. Alternatively, holding that the contract was void because the appellant had actual or alternatively constructive knowledge of the respondent's mistake. The appellant appealed to the Court of Appeal. The appeal was dismissed. Hence, this case dealing with the issues of the non-mistaken party have constructive knowledge of the mistake should be distinguished from our case. As the disputed trade concluded upon the agreement of the smart contract in the present case when the both parties were asleep and unaware of the unusual change in market conditions on the Clarity platform. The main issue in Digiland Mall case was the respondent knew of the mistake. It was a unilateral mistake. However, in our case, there is no unilateral mistake, as both the parties were in the same state of mind when the trade concluded, and both were informed about the trade being conducted when they woke up. Therefore, for a unilateral mistake to take place, one party needs to be informed of the mistake. But in our case, that was not the issue. Furthermore, Your Honor, I would like to draw your attention to a point on page 19, last line, starting from in the absence of actual knowledge, that is continuing to the page 20. This point highlighted that when there is no actual knowledge on the part of the non-mistaken party, a contract should not be declared void since both the parties were unaware of the mistake. Moreover, I would like to direct your honor to page 20 again, 15th line, starting from knowledge. This point shed light on the fact that actual knowledge shall be construed through express admission or infutable evidence. However, since both of these elements are not present in our case, it makes it certain that the appellant never had knowledge of the error and had only got to know of it when the respondent knew of it. Therefore, this case needs to be distinguished from the present case as the appellant did not have the actual knowledge of the error and trade being concluded on its basis, resulting in no unilateral mistake. If Your Honor has no further questions, I shall proceed to my second issue under this submission.
See.
The second issue under the submission can be found on page 6, para 11, Your Honor. The second issue is that both parties' program transited within its parameters, and the condition under which the respondent's program was programmed was not aware by the appellant. If it pleases Your Honor, I would like to refer you to the case Thornton and Shoon Lane Parking Limited, reported in the second volume of the 1971 Queen's Bench at page 163. For Your Honor's benefit, I would like to direct you to page 6, para 12 of the skeleton argument in the appellant bundle. For further judgment on the case, I would like to guide Your Honor by clicking on the case in the index on page number 1. Would Your Honor prefer a brief summary of the following case?
Yes, please.
The facts of the Thornton case are as follows. The plaintiff drove his car into a new automatic car park. He had not been there before. The plaintiff took the ticket to enter the garage where his car was parked by mechanical means. On the plaintiff's return to collect the car, there was an accident and he was severely injured. The plaintiff claimed damages from the defendant's garage. The defendant contended that the ticket incorporated a condition expecting them from liability. It was held at the end that since the plaintiff did not know of the exception condition and the defendant had not done what reasonably sufficient to bring it to his notice, it did not exempt them from liability. Hence, this case needs to be applied to the present case in a way that appellant did not know about the conditions under which the respondent's program was programmed. Since each algorithm has its own characteristics, it is unfair to claim that appellant would have been aware of the respondent's program. Additionally, there is no fact in the present case in relation to if the respondent tried to tell appellant about his program condition, nor it is clear if both the parties had traded before on clevity. Moreover, I would like to direct Your Honor to page 13, para 1, in which it is explicitly stated that conditions need to be brought to the notice of the other party. And in the present case, nothing of such matter was done. Furthermore, I would like to direct Your Honor to page 15, para 6, that continues to page 15, second line, that when the parties accept the contract, the conditions under it are not important. Therefore, in the present case, both the parties' program contained pre-programmed instructions about when to buy and sell. And these algorithms, once activated, trade autonomously in accordance with the programming. Hence, this means that both parties functioned under its set algorithm by them and concluded the trade under the smart contract. And the acceptance was made when the program was activated due to the malfunction that occurred on clevity. Followingly, on page 16, para 10, that followed page 16, second line, explicitly infers that if a condition is known to a reasonable man, then only they are bound by it. But in our case, there is no such issue, as the conditions under which the respondent's program functioned were unknown to the appellant. Nevertheless, the trade concluded through the smart contract when both the parties were not aware of the transition. Furthermore, under the conditions set by the parties in the programs, it was too late for the appellant to have taken action to prevent the disputed trade, as the appellant was asleep. Therefore, a reasonable person would not void the concluded trade as the transition had been done through an algorithm known to the respective parties. With this, I conclude my first submission. Does Your Honor have any questions regarding the first submission?
No, thank you.
If it pleases Your Honor, now I would like to proceed to my second submission. The second submission in the appellant bundle can be found by clicking on the second ground of appeal in the index. The second submission in this case is that the respondent should have been aware of the risk when accepting to algorithm trading through the smart contract. The respondent, as a reasonable person, should have been aware of the consequences when she programmed alpha, as algorithm trading is an inherent issue of trading. I would like to direct Your Honor to the ground of appeal 2 on the index, through if Your Honor could move down to 7, para 15. Article 37, Section 2B of the DIFC contract law explicitly states that if the mistaken party, which in our case is the respondent, is aware of the potential risk due to the circumstances, the mistaken party cannot void the contract. Hence, since algorithm trading comes with its own risk, it is imperative for all traders to be aware of the risk, and a malfunction in the program is no exception to this risk. Therefore, the respondent should have programmed his program to cope with the risk he was well aware of, as he is a common user of clevity, or should be able to endure the damages that come with taking such type of risk. Nevertheless, the manner the respondent programmed her program proves that she accepted the potential risk the program could cause. Therefore, even if the respondent made a mistake when she programmed alpha, the appellant did not make a mistake in programming beta, causing the respondent not to void the contract in accordance with Article 7(2)(b). With this, Your Honor, my second submission is concluded. If Your Honor has no further questions, I shall proceed with my conclusion.
Please proceed.
To conclude, there is no unilateral mistake, as appellant was unaware of the malfunction. The respondent accepted to do the trading under the smart contract and to take the risk of trading through algorithm tradings. And for these reasons, the judge erred in dismissing the appellant's claim. The judge should have held that the claim succeeded because the concluded trade had been formed between the parties through the smart contract. Your Honor, you have heard from my learned senior that the authorities favor the smart agreement as being valid and that there is no misrepresentation by the appellant. Accordingly, I would like Your Honor to find in favor of the appellant by upholding the appeal and overturning the decision of the trial judge. Unless Your Honor has any further questions, that concludes the case of the appellant.
Thank you, counsel. I now invite the respondents to start their submissions.
Good morning. Am I audible?
Yes.
All right. Good morning and may it please the court. My name is Ms. Nabiha Khan, Senior Counsel for the respondent, Ms. Raz Rani, along with Mr. Moot Khan, Junior Counsel for the respondent. I will be addressing the first ground of appeal. For the benefit of Your Honor, I shall reiterate the facts of our current case relevant to my submission. On June 10, 2022, a glitch in Clevity led to the appellant and the respondent being the only parties allowed to trade on the platform. Due to the programs of the parties, Mr. Laith Payne, the appellant, sold the cryptocurrency Yapple at a price 250 times greater than the prevailing market price, which I will refer to as a disputed trade. Upon issuing proceedings in the DIFC courts by Ms. Rani, Mr. Payne, the appellant, challenged the court's jurisdiction. It must be noted that the Court of First Instance dismissed the appellant's application under Article 5A1 subsection B of Dubai Law No. 12 of 2004, which I will refer to as the Judicial Authority Law, and decided that the DIFC courts do have authority to judge the case. Your Honor, with these facts stated, I have three submissions to make, negating the first ground of appeal, challenging jurisdiction. First, the appellant did not provide evidence and a good arguable case that DIFC courts' jurisdictions fails to apply to the current case. Second, the contract was partly performed in the DIFC, allowing DIFC courts to govern the disputed trade. And third, that the location of the nodes determines that DIFC jurisdiction does apply to this trade. With regards to my first submission, that is the appellant needing to provide evidence and a good argument, I would like to cite DIFC Court Rules Part 12.10 found on page number 31 of our court bundle, which states, if a defendant makes an application under this part, he must file and serve his written evidence in support with the application notice. According to the facts of our current case, the appellant did not provide any written evidence supporting his application. Furthermore, I would like to mention the case of Tulip Trading Limited versus Bitcoin Association for BSV reported in the Chancery Division of the England and Wales High Court in the year 2022, starting on page 667, which is found on page number 274 of the Respondent's Court Bundle. Your Honor, would you like me to summarize the facts of the case?
Yes, that would be helpful. Thank you.
The facts of this case revolve around the claimant who allegedly owned $4.5 billion of Bitcoin on the defendant's networks. In the same year, the CEO's computer was hacked and the private keys had been erased, due to which the claimant issued proceedings. And the defendants argued that none of them resided in the jurisdiction, hence they should be opted out of the English courts. In this instance, the court held that the claimant has to satisfy that there was a good, arguable case that the claim fell within one or more of the jurisdictional gateways. Also, in the case of Howard Norman Leedham versus Oxford Investment Managers Limited, case number 6 of the year 2008, in the DIFC courts of first instance, held on 22nd June 2010, which will be found on page number 195 of the Respondent's Court Bundle. I would not be stating the facts of this case because they are not applicable to our current case. However, my argument arises from the court stating that if the DIFC court's jurisdiction is challenged, the claimant must satisfy that the DIFC court has jurisdiction according to Article 5 of the DIFC Judicial Authority Law, which I will cite later on. Your Honor, bearing these authorities in mind, it is my first submission that according to the facts of our current case, the appellant did not provide any written evidence or any good arguable case supporting his application challenging DIFC courts. If Your Honor has no questions, I would like to move on to my second submission.
Please proceed.
My second submission will be divided into two parts. First, the transaction between Ms. Rasrani and Mr. Payne qualifies as a contract. And second, this contract was partly performed in the DIFC, and hence the DIFC courts do have jurisdiction to govern this disputed trade. With regards to my first part, I would like to mention Carlisle v. Carbolic Smokeball Company, published in the first volume of the Queen's Bench of the year 1893, starting on page 256 of our court bundle. I will briefly go over the facts relevant to my submission. Here, the claimant purchased the product the defendant was advertising, and the courts held that to be a unilateral contract. Similarly, in our current case, $250,000 were debited from Ms. Rasrani's account in exchange for 100 Yapple from Mr. Leith, and therefore this transaction also qualifies as a contract based on my before-mentioned case. Proceeding to the second part of my submission, I would like to reapply the case of Al-Khafari versus Bank Saracen, the third case of the year 2011, held in the DIFC Court of Appeal on 5th January 2012, which will be found on 285th page of our court bundle. And this case was used in the court of first instance. However, Your Honor, I'd like to bring to the court's attention a different application of this case, which is that the DIFC courts judged this case because one of the parties was living in Dubai, and since DIFC jurisdiction is an opt-in jurisdiction, it satisfies Article 5A1 subsection B and subsection C of Law number 16 of 2011. And this law can be found on page number 274 of our court bundle. For the benefit of the court, I would like to state both these subsections. Article 5A1B states, civil or commercial claims and actions arising out of or relating to a contract or a promised contract, whether partly or wholly concluded, finalized or performed within the DIFC, or will be performed or is supposed to be performed pursuant to expressed or implied terms. And subsection C states, civil or commercial claims and actions arising out of or relating to any incident or transaction which has been wholly or partly performed within DIFC and is related to DIFC activities. Now, if we apply this to my client's case, as mentioned before, the DIFC jurisdiction is an opt-in jurisdiction, which implies that Ms. Rani, regardless of not living in the DIFC, still can issue proceedings in the DIFC courts. And therefore, my argument is that Ms. Rani took part in this contract in the DIFC and hence satisfies both the articles, Article 5A1, subsection B and subsection C. Now, my final argument is that the location of the nodes is another vital aspect in determining the jurisdiction of cryptocurrency transactions. And I would like to introduce two authorities for the sake of this submission. The first being a landmark case for future jurisdiction claims related to cryptocurrency, the case of Tezos Securities litigation held in the 148th District of the United States District Court for the Northern District of California, with the case number 317 CV 06779 RS. This is available on page number 424 of our Respondent's Court Bundle. The fundamental allegation in this case was that for over 2 weeks in July of 2017, the defendants unlawfully conducted an initial coin offering, also called as ICOs, for tokens called Tezos. And during this period, the investors contributed digital currencies, including Bitcoin and Ethereum, and the plaintiffs specifically dealt with Ethereum. The California District Court decided that they had jurisdiction over these transactions by analyzing multiple factors, one being the presence of the Ethereum nodes in the United States. The court held that these factors support the conclusion that the purchases occurred in the United States. And I would like to submit another authority in support of the previously mentioned case, an article by one of the world's leading law firms, DLA Piper. In this article, titled Blockchain, Backgrounds, Challenges, and Legal Issues, published on 2nd February 2018, which will be found on page number 422 in the Respondent's Court Bundle. It is specifically stated that at its simplest level, every transaction could potentially fall under the jurisdictions of the location of each and every node in the network. Now, applying these authorities to our current case, it is well known that there is one node of Clevity in the DIFC, and therefore the mere presence of this node in the DIFC provides a substantial argument supporting my client, Ms. Rasrani's claims the DIFC courts do have jurisdiction and authority to govern the disputed trade. Your Honor, I would thus like to conclude my submissions and urge the court to uphold the court of first instance judgment and quash Mr. Payne's claim for DIFC court not having jurisdiction over the disputed trade. Thank you.
Thank you, counsel. We can proceed with the remaining counsels in your team. I don't have any questions. Thank you.
Thank you, Your Honor.
May it please the court, as introduced by my learned senior, Ms. Nabiha Khan, my name is Mr. Momin Khan, Junior Counsel for the respondent, Ms. Raz Rani. I will be addressing the second ground of appeal. For the benefit of the court, I shall reiterate the facts of the case relevant to my submission. As stated previously by my learned senior, the response.
I think we can skip the facts. It's okay.
Okay.
Thank you.
I will not be disputing or arguing regarding the court of first instance's decision to apply Lord Mance's reasoning. Instead, my submissions will contend with the circumstances surrounding the mistake and why my client believed that there is a valid claim for the voidance of the contract. My first submission is based on the case of Statoil ASA and Louis Dreyfus Energy Services LP, reported in the House of Commons of the England and Wales High Court in the year 2008, starting on page 2257. Would Your Honor like me to reiterate the facts of the case?
Okay, sure.
This case concerns Statoil ASA, a Norwegian oil and gas trading company that sought a sum of $435,833 from the buyer Louis Dreyfus Energy Services LP as the balance of demurrage that they were owed under a contract term for the sale of liquid propane gas. The ship chartered by the plaintiff had failed to discharge the cargo on time, which led the plaintiff to send a demurrage claim to the defendant. There was an error regarding the date mentioned in the claim, which changed the price from the previous $435,833 to $103,527 The defendant's representative had realized the mistake, but decided not to bring it to the plaintiff's attention. The amount mentioned in the incorrect demurrage claim was accepted, and both parties proceeded accordingly. It was only after a further, more careful inspection that the plaintiffs discovered the error and updated the demurrage claim to reflect the true amount owed. The plaintiff submitted that the first invoice was void or voidable for unilateral mistake, and that the defendant had eventually accepted the revised amount. However, the defendant denied this and claimed that it was too late for the plaintiff to demand the original correct amount. Mr. Justice Eikens, in the Commercial Court of the Queen's Bench Division, found in favor of the plaintiffs and concluded, among other things, that the price of a contract is its most fundamental term. This finding was made in his analysis of the case of Shui King Kyung and others versus digitalandmall.com Pte Limited, published in the second volume of the Law Reform Committee of the year 2005, starting on page 28, which I will be discussing further in a later submission. As I have now submitted that the price of a contract is its most important term, I would now like to make a submission pertaining to the two different kinds of internationally recognized unilateral mistakes. There is mistake at common law, which is the only approach recognized now by the English courts, and mistake at equity, which is an equitable doctrine recognized by the Singaporean courts. I would contend that the circumstances of this case fall very squarely within the parameters laid out by both the English and the Singaporean courts. This submission will be divided into two parts. First, the doctrine of mistake at common law adopted by the English courts. I would like to mention the case of Longley and PBB Entertainment Limited and others, published in the Queen's Bench of the England and Wales High Court of the year 2022, starting on page 977, whose facts revolve around the claimant. Would Your Honor like me to iterate the facts of this case?
Yes, please.
The claimant was an experienced gambler in betting on horses. He wanted to place a bet of £1,300 on one of the horses through a call operator. The operator erroneously sought approval and placed a bet of £13,000 instead. The horse that the claimant bet on won, and £286,000 were credited to the claimant's online account. When the betting company realized the mistake, they recalibrated the amount to £28,600, in line with his initial bet of £1,300. Consequently, the claimant issued proceedings for breach of contract. Justice Ellen Bogan stated that a mistake regarding a contract must be to the terms of the contract. Furthermore, where one party was aware of the mistake made by the other party, yet still concluded the contract would be void. Your Honor, bearing these facts in mind, alongside the previous submission that the price is the most fundamental term of the contract, it is my contention that the disputed trade concluded by Mr. Payne and Ms. Sinani's algorithms made a mistake to the most fundamental term of the contract. I would like to further contend that upon discovering this mistake, Mr. Payne insisted on the trade being upheld. The court of first instance found that it was sufficient that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the disputed trade was the result of an error. To insist on that error as being anything but a mistake is contrary to the law found in the English legal system and in direct conflict with the doctrine of unilateral mistake at common law. As the price is the most fundamental term of the contract according to Statoil ASA, a mistake at common law must be to the term of the contract, and concluding a contract that was formed on the basis of a mistake voids that contract. I would like to submit that the contract between Mr. Payne and Ms. Rani can be found void at common law. Secondly, I would like to submit an alternative approach of mistake in equity laid out by the Singaporean courts in the case of Shui King Kong and others and digitalmall.com Private Limited. The facts of the case are as follows. Would Your Honor like me to iterate them?
Yeah, sure.
Around 6 plaintiffs placed an order for laser printers on the defendant's website, which were priced at $66 each. The price of the $66 was uploaded by the defendant party mistakenly, and when the error was discovered, the defendant removed the advertisement from the website and informed the plaintiffs, along with the other 778 people who placed these orders, that the purchases would not be concluded. Here, the court argued for the existence of a parallel iteration of unilateral mistake and equity. It was held that the requirements were constructive knowledge of the mistake and unconscionable conduct in relation to that mistake, and if both were discovered, the contract would be voidable. In applying this test to our case, it can be said that upon the findings of the court of first instance, Mr. Payne could have concluded that the trade was the result of an error in the same way a reasonable trader would have. The court of first instance ruled out the notion of needing to analyze a trader's state of mind at the time of programming the algorithm, so it can be said that Mr. Payne had constructive knowledge of the mistake. Furthermore, his insistence on upholding the trade and keeping the unjust enrichment he received could undoubtedly be said to be unconscionable conduct in relation to that mistake. Upon applying the facts of our case to the test laid out in the Singaporean courts, it can be concluded that this contract also falls squarely within the definition of a unilateral mistake in equity. Lastly, I would like to cite Article 37, Section 1, Subsection A of the DIFC contract law. It states that a party may only avoid a contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known, and if the other party made the same mistake or was also mistaken or caused the mistake or knew or ought to have known of the mistake and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. In applying the contract law of the DIFC to our case, it can be concluded based on the findings of the court of first instance, and here in my submissions, that the mistake does fall under the criteria mentioned. Namely, the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known. And the other party knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. A trade concluded at an inflated price of 250 times the prevailing market price could hardly be regarded as a situation that is beneficial to both parties. Furthermore, if Ms. Rani had not immediately become aware of the mistake and Mr. Payne had taken his unjust enrichment without bringing the mistake to her attention, it would undoubtedly have fallen within the scope of Article 37's reasonable commercial standards of fair dealing section. As Mr. Payne's actions have clearly indicated at this point, he does wish to keep the contract as it is. Allowing the contract to remain as it is and not avoiding it would, based on the findings here, completely contravene the aforementioned text of Article 37, Section 1, subsection A of the DIFC contract law, and as such, relevant mistake can be found here. It is therefore my conclusion on the facts and the test presented in my submissions that this situation before us falls within the criteria to void a contract under the English test for mistake at common law, the Singaporean test for mistake at equity, and even the DIFC contract law test for relevant mistake. By three separate and internationally recognized systems in their tests, it would be unjust and contrary to commercial standards to allow this contract to be valid. Your Honor, I would request that this appeal be dismissed and the judgment of the court of first instance be upheld. That is all.
This is Ahmed Al-Rais. I've been joining this session as a designated judge. I was hearing to your statement, but I'm not sure whether these facts which you have already mentioned, it is relevant to the case. So as you know, this is a digital economy, a platform, and programmed by itself. The intervention of the human being is I think there's zero intervention. So all these facts which you have announced and which you have mentioned in your statement, how you tie and link these facts to the digital economy transactions?
I believe that the test mentioned in the English and Singaporean courts and the DIFC courts have been applied in the past to other cases of digital trading, and thus they also here hold precedent.
So you are relying on this precedent?
Yes, as I mentioned, as seen in the judgment of the court of first instance, there was a similar case, Coin and B2C2 Limited, where there was also a trade regarding the matter of digital economy, and that was concluded with cases mentioned specifically, like the ones I mentioned. In the English
It's
court
okay.
and
It's
the
okay.
Finnish court.
It's okay. I have joined a little bit late, but let me ask you, if this precedence is 100% similar to our case, or there is some differences in that one, because as you know, in this transaction, it's self-programmed. There is no intervention of human being at all, and it's being programmed on such circumstances. Am I right?
Yes, undoubtedly.
So if something happens, yeah, okay. So if something happens, can you hear me well? I think someone is opening the mic.
Yes, I can.
Okay, I'm saying now, if something happened now in this transaction and it's caused by the program and there is no intervention of human being, and do you think it's for the sake of justice to rely on your statement? If you are in this part, in this position, what you will go for?
I think the facts of two cases that I mentioned also had no human intervention. There were mistakes made by third parties, and as such, the facts here are similar to the cases I mentioned, and it wouldn't be fair to uphold a contract on that basis.
Thank you.
Thank you.
Thank you to both the teams, the applicant and the respondent teams. I don't have any questions. I would just request my fellow judge from Mr. Al-Risi Advocates if you have any further questions for the teams. You're on mute.
Thank you, Mr. Fishwan. I don't have any further questions, and I think the time is now 10 o'clock. So I think we are more than time that we located for this session.
Perfect. I would just like to thank both the teams, the Middlesex University I and Middlesex University the H. Thank you so much.
Thank you very much.
Thank you. Thank you very much.
Thank you.